Good afternoon, everybody. Well, I guess for people joining us from other time zones, maybe morning or evening. I think it's evening for our presenter, Scott Gaddis, who will be telling us about cyber insurance, how I learned to stop worrying and love the policy. It occurs to me that probably only lawyers love policies and maybe some insurance adjusters as well. But hopefully, by the time you finish this program, all of you will love the policy as much as Scott does. Scott is a partner at Barnes and Thornburg in Washington, D.C., and he is the most interesting insurance lawyer in the world. He has practiced in the area of cyber security and privacy claim coverage, representing policyholders for about 13 years, since 2008. So he was really on the ground floor of this area of practice. He's litigated the scope of insurance coverage for data breach claims under cyber policies. He's recovered millions for data privacy incidents and cyber attacks under policies covering cyber crime, commercial general liability, first-party property and tech errors and omissions, among others, including professional liability. And he provides strategic coverage advice for companies with cloud-based privacy and cybersecurity events. That's what Scott informed me is known as a breach coach, having nothing to do with birthing babies, by the way. He's got a long history with the American Bar Association's litigation insurance coverage section, with their cyber risk and data privacy subcommittee, and the computer technology subcommittee. So without further ado, let me mention a couple of things. You will receive your MCLE certificates from the bar. They'll be emailed to you within the next day or two. So be on the lookout for that. And you should have program materials that were attached to a 1 hour notice email. So that was sent out maybe an hour or so ago. And they're also in the chat. There's a link to the program materials there as well. So let's move forward. Scott, thank you for being with us.
Thanks, Mike. Okay, buckle up for an exciting hour of insurance for cyber risk. Thank you, all of you masochists, for joining. I know insurance is probably one of the least interesting subject matters out there, but I will do my best to make it interesting and live up to that title of most interesting insurance lawyer in the world, a real title that was given to me by actually one of your colleagues in LA. So there was me, and there is Mike.
Yeah, that's me. All right, let's move on. I want to let our listeners know, our viewers know that if you have questions or comments, you can use the chat feature at the bottom of the screen, or there's a Q&A and I will be monitoring both of those for questions that we can ask Scott as his program continues. I'm sorry to interrupt you.
No, not at all. I welcome more questions. I welcome interaction with Mike, with you, because I have a couple of kids at home and I haven't finished a sentence since 2005. So I am totally prepared for that. Back to the roadmap, if you will, telling you what I'm going to tell you. There are three real issues that are driving cyber and data privacy risks, in addition to your state continuing to pass statute and statute after statute regarding privacy and being the leader in the country for that. I'm going to talk about business email compromises, talk about ransomware, talk about payment card industry risks. And I'm not going to focus so much on CCPA. We can certainly address that to the extent that there are questions on how insurance applies. And after having worked through the scenarios, for those of you who are not familiar or want to get a little more familiar with the latest and greatest, I'll talk about what to look for in a cyber insurance policy, either for you or for your clients that come to you with these questions, and what are some best practices in terms of working with the insurance carrier and the various parties when an event actually takes place. So business email compromises, if you were reading while listening, I'm not going to do death by PowerPoint here. I'm not going to tell you about this case. This is an example case from the Sixth Circuit. And really what the issues that have come about in the context of business email compromises are two. One is the oldest one, really started happening in earnest in the early 2010s. And then several insurance cases arose from that, one of which I took one of the Federal District Court and one on the 11th Circuit Court of Appeals in terms of crime insurance, where somebody gets an email that says something along the lines of, hey, this is your boss. It's Friday. I'm out of town today, and I need you to be my right-hand person and help us close a deal. We are making a significant acquisition, and therefore I need you to send some money. You'll hear from other people. And invariably, people ultimately go for it. And you can sit back and say, well, how could they be so, so gullible to fall for that? It happens all the time. And so the situation in which I worked was somebody wired $1.717 million to fraudsters in China. And then what? Where does the insurance apply? The insurance carrier said they wouldn't cover. And we were off to the races, unfortunately. Another more common and more frequent example today is a situation in which business partners, like in this, the Townsend Ford Lincoln case, business partners exchange emails. The buyer ultimately is tricked into sending funds for the product or services to the fraudster rather than paying the seller. And so then what? Who's responsible for that payment? Well, that's really a scenario that courts have been wrestling with lately. It is very much a situation of putting new wine in old bottles. You'll hear me use lots of stupid analogies, and that's just one of them. But the issue is courts are struggling with this. And I'm not here to resolve and tell you how to litigate these cases, but rather the issues that come up and how insurance can help mitigate the costs of dealing with these, the cost of the losses, and et cetera. And so this comes up again in the context of here's how the vendor versus business partner situation works out. The seller, their system gets hacked. So the seller has sold goods to the buyer, and the seller gets hacked, and the buyer and the seller sends an email out to the buyer that says, hey, listen, we're undergoing an audit. Don't send your $750,000 payment the usual way. Send it by wire and send it to this account. While we're undergoing the audit, we're not doing anything with our current bank account, so please send it in a different way. And the buyer doesn't think anything of it because maybe the email even came in a thread through which they had been communicating with the seller previously, and says, okay, and they send the $750 to the fraudsters, not to the buyer. Now, is it the responsibility of is it not to the seller? Is it the responsibility of the buyer who fell for the trick to be responsible for paying a second time? Or is it the responsibility of the seller for not having sufficiently good computer security, network security, to prevent this from happening? There's your old wine, new bottles. How does this allocation of fault work out? And then whose insurance pays for it? And moreover, if one party's insurance does pay for it, does it chase the other party down through subrogation? The idea that insurance carrier steps into your shoes and chases them down. Second one I mentioned is ransomware. Undoubtedly, you all have heard of ransomware in one form or another in the past. And so this is an example case, again, where actually the insurance carrier made a payment for the ransomware-based losses to the policyholder and then chased down the party that they said ultimately was responsible, and it ended up getting resolved through arbitration rather than through this litigation. So we don't know how it ultimately worked out. What are we seeing now in terms of changes and developments in the area of ransomware? Well, what we're seeing is demands are going higher and higher. I've been working on ransomware cases since probably 2014 or so. The most recent ones I've worked on have had 8-figure demands for ransom, whereas they had started out in the low 7-figure, low 7-figure, high 6-figure, maybe even 5 to 6-figure numbers. We're starting to see a lot more frequency of demands that are in the 8-figure range. So it's not really a good day when you or your clients are facing a situation where they're saying, if you want your system to be unlocked, then you've got to pay $12 million. Now, as an aside, all of the things that I'm talking about, you'll say, boy, this sounds completely ridiculous. That's not going to happen to me, or these facts have to be completely fantastical just for effect. All of the facts that I'm telling you about and all the scenarios I'm telling you about are real live cases, real live scenarios, either from case law or from other things that I know about personally, which I won't disclose further to not reveal client confidences. But you can believe me, Scout's honor, if I was ever a Boy Scout, that these are actual legitimate true stories. Second thing that's happening now is threat actors are going back again. So this is the funny thing, like, are your criminals honorable criminals or are they not? What I mean by that is, let me talk to you about a case that went up to appeal the Indiana Supreme Court, where I served as an attorney for the amicus party representing the entities that were saying that this should be covered. The threat actor, the term of art for the criminals, said if you want your systems to be unlocked, you have to pay 2 Bitcoin, which at the time, again, this was an older case. This was worth about $35,000, $40,000. 2 Bitcoins if you want to unlock your system. And so they engaged them, they engaged law enforcement, and the threat actor said, okay, they paid the 2 Bitcoin. They said, here are your keys. And it turns out the keys didn't unlock everything. And they went back to the threat actor and said, hey, you criminals, I can't believe you lied to us. Well, and they said, all right, well, if you want to actually unlock the rest of your system, you got to send us another Bitcoin. And so they did. So that's a second bite of the apple, asking for more money. Or alternatively, if you don't clean your system sufficiently, coming back and hitting you again with another ransomware attack. I know of a circumstance in which a party thought that they could restore their system without paying the ransom. They figured they would restore from backup. And while they were restoring their system, they watched server after server go down and get locked up because the threat actor had never been fully removed from the system. And finally, the latest is that threat actors are realizing that people figure, well, paying a criminal is a terrible thing, I won't do it, that they now engage in old-fashioned extortion and say, well, even if you think you can get your system back up without paying for the key, then we're going to disclose all your corporate secrets, your personally identifiable information, which would constitute, they know, a data breach under certain state laws. And they threaten to shame you and release this information online if you don't actually pay the ransom.
Those two things are somewhat related, right? Because I know you and I talked about, I think everybody knows, most savvy people right now, their attitude is, well, I make a copy of everything, I keep it off site. And so if I am hit, theoretically, I could just reload all of my stored data onto the server or to a server that's not connected to that same network and get back in business. So this is a way for the threat actors to get around that and maintain pressure on our client or our insured, right?
That's exactly right. And then to further that point, Mike, one of the things that comes about is, you're right, people think to themselves, well, I've got a really great IT system and I back up every day, or I've got a continuously operating back, whatever it might be, so I'll be okay. Unless the ransomware, the malware actually gets into the backup as well. And crazily enough, the more frequently and regularly you back up, the more significant the chance is that the ransomware gets into the backup. And so the first or second ransomware matter on which I worked was a company in Silicon Valley. And they engaged in very appropriate risk management for a company that is at risk for an earthquake or something else that would affect the integrity of their physical systems. And so for every piece of data that came in, it immediately got copied and sent off to an offsite backup storage system, which is great unless you're backing up the ransomware to your backup. And so that's exactly what happened, is that by being careful for things like traditional risks, they actually sent the malware right off to their backup, and that got encrypted as well. So they had to pay for the unlocking and getting a key. Okay, so another update, OFAC, which is the Office of Foreign Asset Control, there's been some guidance, and this has really gotten people pretty agitated, a lot of consternation around the OFAC guidance. And you said, well, what are you even talking about? And so what I mean by that is the Office of Foreign Assets Control says you cannot do business with, you cannot make payments to terrorists or terrorist countries or et cetera. And there's a list of a do not fly list, if you will, for certain countries and certain actors that are known. So that puts you in a terrible spot you being
If your threat actor is a terrorist organization, basically.
Yeah, exactly. Now there are some that are known, but then otherwise you have to prove that they are not. OFAC does have sanctions and potential for criminal penalties. And so one would not want to run afoul of that. Just as significant, your insurance carrier will want to be certain that any payment that you have made for which you are seeking reimbursement, your clients are seeking reimbursement, are cleared, and that there's been some kind of quote unquote sanctions check made, that they're cleared. Because insurance carriers will pipe up and say, it turns out we think that there's some intelligence that ties this threat actor to someone on the do not fly list or a country in the do not fly list. We will not reimburse you. That's really an unpleasant day when that comes around, and trying to figure out how can you convince an insurance carrier, again, proving the negative, that notwithstanding what they've heard, they should pay anyway, and that they should believe you and not the smattering of intelligence that they heard here or there for that. And I've seen exactly that, where there has been some intelligence by forensic firms that monitor the dark web, and they come out and they say, well, we saw some chatter in a chat room, believe it or not, this is what they will say, that ties this entity to Iran. And then an insurance carrier says, well, we're not going to make a payment then because Iran's on the OFAC do not fly list. And so therefore, we can't reimburse you. And that's a really unpleasant day for the policyholder, particularly unpleasant if the insurance carrier makes that determination after saying, yeah, you're clear to go ahead and make that payment.
So you and I talked about the possibility that the carrier, if they made the payment of ransom directly, might be held liable for violating these OFAC restrictions.
Right. And that's exactly, go ahead, Mike, go ahead.
Would reimbursement also be violative of the restrictions?
That's their position, because their position is that they could be held liable for facilitating a payment. And I really would have to turn to my international trade partners to explain to you the exact chain of risk there, but the carriers take the position that they're as much at risk as the policyholder that makes the payment, such that they will not do so. Or there are certain carriers that have said that they will not do so in the context of a situation exactly like that.
Even for reimbursement?
Even for reimbursement, yeah, you've got it. So a lot of the news stories, and if you've been fortunate to not have gone through ransomware, certainly you know about the ransom demands. But other things for policyholders and those of us who advise, and those of you who advise companies about these risks, here is a list of things, other things to think about, and think about how could I get insurance to pay for these things. When these sorts of things happen, companies typically bring in outside counsel to advise them. They typically bring in someone called a breach coach, which tells them about privacy obligations, cybersecurity obligations, contractual, regulatory, statutory obligations, et cetera. There is the situation where companies and organizations lose revenues. And so particularly those that are consumer facing, that don't have long-term contracts, will be able to say, well, okay, we normally make X amount of dollars. We were down for this amount of time, and here's how much we lost. That's something that tends to not get focused upon by the news when talking about ransomware and the potential losses. Customer claims is another one. Customers a lot of times will come in and say, well, gosh, I did have a contract with you and you were down for 5 days. I didn't get the value of my service for 5 days. So I want you to pay me or make me whole.
Or
and
the
other things,
consequential damages as a result of the outage, right?
I'm sorry, Mike, I missed you there. Could you repeat that?
The customer claims could include consequential damages as a result of the outage, right?
That's exactly right. Yep. And they will and have made that kind of demand. And then the business has to sit back and say, well, what are we going to do about this? And how can we get it resolved? Last item on the list of what to be worried about, in addition to CCPA, are payment card issues. Now, this is one that is kind of the grandfather of all cyber risks, in that criminals used to steal credit cards in large scale. You probably remember some retail chains from the 2013 to 15 timeframe that got hit with payment card events like this. And what ends up happening is there undoubtedly are aggressive plaintiffs lawyers that bring class actions even some banks bring class actions. The payment card brands actually come in through the processor and say, the party that got hacked is responsible for the fraudulent charges and card replacement costs. So if you've ever gotten one of those phone calls saying, hey, did you make this charge at this location? You say no, they say that's fine. You're not responsible for it. We'll get you a new card out. Well, then they turn back to the party that was hacked and say, you're ultimately responsible, hacked party, for reimbursing the amount of the fraudulent charge, and you're responsible for the cost of the new card and the mailing. We'll multiply that by millions and it adds up pretty quickly. Or even by thousands for a smaller organization. Again, it adds up quickly, gets to be very, very expensive. So what do we do about it? Well, that's what I'm here for. Risk transfer methods insurance, to do a little death by PowerPoint and read you what I wrote. Here is a list of insurance policies that can potentially provide coverage for these sorts of risks and losses.
Scott,
And so
can I
you
ask you a
will
question?
hear,
Can I ask
yeah,
you a question?
please.
What's the difference between a cyber insurance policy and a tech errors and omissions policy?
Sometimes nothing. To give you my favorite answer as a lawyer, it depends. And here's what I mean by that. A tech errors and omissions policy, technology errors and omissions policy, at bottom, is a professional liability insurance policy for a company that provides technology services and products. Probably no surprise there. So that means, hey, if you get sued or someone makes a demand against you saying that you rendered services usually in a negligent manner, there was an act, error, or omission that resulted in damages to and harm to them, the third party, that's where tech E&O, you would look to that first. And the reason I say it depends is that tech E&O oftentimes can be included within a cyber insurance policy. And so for companies that provide professional services might have technology errors and omissions as insuring agreement 1 or 1.A, and then cyber insurance coverages through the rest. And so you can see them kind of all rolled into one policy. A lot of the policies on these lists actually have explicit coverage for the risks that I've been talking about, we'll continue talking about. Crime insurance can have coverage for the business email compromise risks. Kidnap, ransom, and extortion, while typically thought of for things like a kidnapping of a person, can actually include specific add-ons for a ransomware event or a cyber extortion event. Although in 2021, 2022, we will probably see fewer and fewer of those endorsements. I'm aware of one carrier that I've been informed is trying to get out of that space because they've made so many payments in that context. Property insurance sometimes has, when I'm talking about a business property insurance, can have some add-on provisions. They have various names and coverages, but they can be pockets of coverage anywhere as low as $5,000 up to $250,000 in a multi-million-dollar policy. Coverage that can apply. $5,000 is typically not going to move the needle. $250 might, but these can be worth taking a look at because I don't know many people that have turned down $250,000 checks or even $5,000 checks if it's the cost of giving notice. So, okay, you're thinking about cyber insurance. You're thinking about cyber insurance for your organization, or you're thinking about cyber insurance, or how do you advise clients that have come to you to say, okay, well, what do I get here? Is this worth the paper it's written on? Should I have it? The answer is yes, you should buy it. You should advise clients to buy it. In the insurance industry, while I have been banging on tables for well over a decade saying that there's coverage in other policies, the industry is getting more and more aggressive about cutting those coverages out of other policies so that a cyber policy is the first place to look. I have a checklist here that is in part to discuss and in part for takeaway materials. So you can learn some of my trade secrets and put them to use. But I put this in there because the running joke that I tell is, if you've seen one cyber insurance policy, you've seen one cyber insurance policy. And the rationale behind that awesome dad joke is that the policies differ. They differ from carrier to carrier. They differ from year to year, in fact. Carriers update them regularly. There is little in the way of standardization amongst carriers for cyber insurance. And there has been a little more of a scenario where what you should expect to see in a cyber insurance policy. But we are far, far away from a situation where if you came to me and said, what kind of coverages are found in a commercial general liability insurance policy, general liability policy, CGL, I'd say, oh, well, of course, it's damages because of bodily injury, damages because of property damage, damages because of personal injury, and damages because of advertising injury. And you'd say, oh, all right, well, what about cyber insurance? Well, it depends. Favorite answer. Again, the carriers are doing everything differently, but what you can expect to see and find in a good standalone cyber insurance policy, not something where they say, oh, well, here's an endorsement to your business owner policy, or here's your endorsement to your media policy, whatever it is. These are things to expect in a standalone cyber policy. The first thing is, in the beginning, again, here I am killing you with PowerPoint by reading what I wrote. What I mean by this is when there is a cyber event, the way that they always get discovered is a couple of different ways. One is the authorities come to you and say, hey, by the way, did you know your systems have been hacked? Or alternatively, someone in your IT department says, hey, did you know we're worried about something along those lines? Now, if it's ransomware, you'll know right away because your systems, well, you actually won't know right away. They've been in your system for a while and figuring out how to lock it up. You'll know the day that they decide to lock it up many, many times on a Friday afternoon. So that's important because a good cyber insurance policy will pay for the costs of hiring a forensics firm to come in and figure out what's going on. What do I do about this? And as you might imagine, if the company the organization has an ongoing cyber attack, not really the time where you have the leverage to bargain shop and figure out who will give me the best price on a forensic investigation. You need someone right away. And it gets to be expensive. The rates that are charged by these firms are similar, if not more expensive than big law firm lawyers' hourly rates. And so having coverage for that is 100% worthwhile. And then there are obligations to take action. Again, talking about California in particular, where we're thinking about here, California Consumer Privacy Act has obligations. There are other obligations. California was the first state in the country to pass a data breach notification statute. Did the threat actor get access to personally identifiable information or protected health information that requires the information holder or owner or both to send out lots of letters to people saying your information's been compromised? That can be really expensive. And so let me go on now. So the other thing is you probably are thinking about is third-party lawsuits, regulatory investigations, and claims. I did an excellent job of reading my own text. So again, the thought here is, gosh, that information got out there. An enterprising plaintiff's lawyer who would tell you that she is operating on behalf of protecting the rights of her clients will file a lawsuit, class action lawsuit, saying, you disclosed all this information that we relied upon you to keep secret. How terrible of you. How did you not have better cybersecurity and data privacy protections in place? Those kinds of things. As you know, either as a lawyer, business people think we're expensive, or if you're a company, you think lawyers are expensive. But either way, you'll want someone to pay for the cost of lawyers to protect you.
So there may be a lot of people at this particular program who are maybe somewhat less familiar with the terminology of insurance, since this is a cyber insurance issue. So just to clarify, first party relates to damages or claims or losses suffered by the policyholder itself. And third party relates to claims brought against the policyholder by, obviously, third parties who claim injury. And so that's why you've got this separated between first party, what you do with your own data, servers, that sort of thing, how you respond to the hack. You're distinguishing that from third party coverage for how other people come after you after the hack for their claims.
Right. So these headings, the bolds, are really taken from the sections of insurance policy you'll see. And right, Mike, that's an excellent explanation. The true insurance nerd in me can't help but to say that even though the company is paying for the costs of for the forensic investigation and potentially for the notification letters. Again, the nerd in me can't help but say, really, it's a third-party liability as the rationale, right? You're obligated to do these things because the law makes you, but the industry loves to call them first-party costs, and so that's why I've titled them that way. But the litigator in me, the insurance nerd in me, can't help but to throw that footnote onto the explanation you just gave. Other things where this is what I would call actually true first-party losses, even in the insurance nerd's heart here. This is business interruption. So again, this is a situation where ransomware locks up the system, or you have some other kind of cyber event, and it makes it more difficult or impossible to stay in business. And perhaps you say to yourself, Self, Scott says he's got a fascinating discussion here, but I don't work for an organization that is going to get hit. Well, who cares about our stuff? We don't have consumer data. We don't have credit card information. We're just not the kind of organization that's going to get hit. Why would I care about business interruption or ransomware or whatever else? No one knows about us. Well, let me give you an example of one of the many kinds of businesses that I've seen has gotten hit and has needed cyber insurance, and believe it or not, actually had it. This is an organization, this is a company in, I can't remember if it was Minnesota or Wisconsin, but let's just pick a place like that, where they have a very seasonal cabin sort of lifestyle, right? Where people go up to their cabins in the summertime. And of course, Memorial Day is the day where everyone else has seasons. That's your first day of summer, unofficial start of summer, and everyone opens up their cabin up there in the upper Northwest. And part of that, of course, is flushing out your septic system. And so you call this business, you say, okay, well, Memorial Day is coming. I need my septic system to be maintained and get my cabin ready for the unofficial start of summer. Well, that business got hit with ransomware right before Memorial Day. So worst possible case scenario for this business. And you would say to yourself, how in the world did a company that flushes out or that deals with septic system problems and basically puts your septic tank in a situation where it can be used for all summer, I won't get into the details, how did they get hit with ransomware? But indeed they did.
Great moments and euphemisms.
Thank you. Indeed they did. And they actually had cyber insurance bought from the London insurance market, Lloyd's of London. So if you're sitting around thinking, I will never, or my clients will never need cyber insurance, will never get hit, keep in mind this poor little septic tank company that got hit, and that means that pretty much anybody can. So, okay, I also talked about business email compromises. Here is a little more color on that, explaining the thoughts of what you should be looking for as a best practice when buying cyber insurance. Is there coverage for these wire frauds and disputes between parties? Now, this warranted its own page because it is a spot where the insurance industry really makes it even more difficult than they already do for buyers of insurance. And what I mean by that is cyber insurance underwriters love to say that they're there to help you out if there's been a data breach, a privacy event, and help you out figure out, oh, how many names were compromised, or how many individuals' information was compromised, and do you have to offer them credit monitoring, and do you have to pay for forensics, and do you have to defend the lawsuit? That's their comfort zone. That's how they started writing coverage. As a buyer, we don't make distinctions between that little nicety and then when they say, well, we don't cover the idea of wire fraud as a result of people being fooled or a computer attack. That's, gosh, we could never underwrite that. That's a crime insurance issue. And so then they want you to turn a totally separate insurance policy, crime insurance. And the crime insurance carriers, those are the ones that I fought with and others fought with kind of the middle of the decade, saying, well, we don't have to cover this either, leaving people with no ability to get covered. Now cyber insurance policies are adding in coverage for these things into their policies. But this is a significant but, only if you're a broker or you know to ask for them. Not every policy has these added in. Some carriers add it in as a starting point. Some carriers do not, but some carriers we'll add it if you've asked for it. And of course, they'll want more money for it, but it is a worthwhile ask and worthwhile consideration.
So that's why you have these parentheses, multiple coverages. So that's telling your client or the policyholder to, yeah, okay.
And multiple places to look and multiple things to think about.
And what
for example,
what kind of terminology do they use? I mean, you know, everybody knows what phishing and spoofing are, but I imagine that's not the way the policy defines it, right? So what?
Sometimes they will have social engineering fraud as part of the title of the endorsement. Again, this varies wildly by carrier, both crime and cyber. And so there's even a thing, for example, let's take our buyer-seller example, where the seller sells a whole bunch of computer equipment to the buyer, and the buyer pays for it. Not that I'm talking about an actual example. The buyer pays $750,000 to the seller. Well, it turns out that the buyer paid a fraudster $750,000 for makes that payment to the fraudster, and then the seller doesn't get paid. So now what? So now if the buyer has crime insurance, the buyer can say to its crime carrier, hey, I got to pay another $750 because the first $750 went to the fraudster. And alternatively, the seller says, I didn't get my $750 because our systems were hacked and the buyer got misled, and boy, they fell for it, but I'm still out $750,000. If you have, some carriers call this invoice manipulation fraud. And there are other names too. Again, it's one of those things you ask your broker as you're getting coverage what it's called. That invoice manipulation fraud coverage is designed to cover a situation where you don't get paid because of an event like this. Be mindful, as a best practice, that these limits are typically significantly lower than the total policy limit. So, for example, not wanting to tell you about a real example, but for example, not giving you a real world example, if you have a $3 million insurance policy, and then there is fraud like this, and you say, great, well, I have a crime policy and I bought social engineering fraud coverage, your carrier might say, well, yes, you did. I know you lost $900,000, but there's $100,000 retention, and there's only $100,000 of coverage for that kind of loss. And you'd say to yourself, well, now the insurance carrier said, well, if you had only read your policy, you would know that. But this again, significant but. The letter, not a real example, of course, I would never do that. The letter that sends out that says, here's what you've agreed to buy, says nothing about the sublimit. And you don't actually get the policy until months after you've purchased it. These are trapdoors for the unwary, which I will also go into as we move forward. So final things to think about when either buying or helping people buy cyber insurance, or answering the question of, is this worth the paper it's written on? The TCPA, people probably know about blast faxes. No one blasts faxes anymore, but what people do love to do is send out text messages. And they love sending out text messages to people that they think have opted in. Well, if the people say, I never opted in, or the sender of the messages loses its entire list of opt-ins, they face liability under the Telephone Consumer Protection Act. And these can be very, very expensive cases to resolve. Carriers know they're expensive. Some carriers will write coverage, some carriers will not. Something to think about. Okay, so moving along, ideally, cyber insurance policy has all the things I talked about. Anything from that first/third-party coverage of investigating and figuring out what happened and what do we do about it, through protecting you, providing you a defense against lawsuits or claims or demands from third parties, dealing with regulators. Here's where the action is. This slide is worth the price of admission, if you ask me. And that's not just because I wrote it, because it's actually valuable. And here's what I mean by that. When you're talking with your broker, or your clients are talking with brokers, what about these things here? These are items that can be added in, oftentimes by request, that will address the kind of the latest and greatest in terms of cyber insurance. And that again, the social engineering that we've talked about and the various ways that it works, I do recommend paying attention to things that are in these endorsements. And so here's one where this just absolutely kills me because that's how much of a nerd I am. Callback requirements. So people love to say, well, if you'd only called me or you'd only called the other party, this never would have happened. Okay, that's fine. We live in a world where people do everything by email or instant message or text message or things along those lines. And so the idea of a callback requirement, some carriers say, well, we will cover this, but only if you called back a number that you had in your contact list before sending the money. Well, that means that like virtually none of these events are going to take place, which is really great as an underwriter to say, hey, we'll sell you coverage that we know will never, ever be impacted. So being mindful of these extra trapdoors is pretty helpful.
So there are policies that have provisions that are that specific, that will say, we'll only pay it if you called back, huh?
Only pay if you call back, and some of them will say if you call back a number that you had in your files previously, so that you're not falling for a telephone number that is listed in the spoofed email.
Wow, amazing.
Yes, it's pretty particular and pretty specific.
So speaking of insurance nerds, the thing that occurred to me was, are there any ISO pages for these policies, or are they all practically manuscript?
There early on were some ISO form. There really has not been much in the way of adoption of the ISO. And so for the non-insurance nerds, that's the Insurance Services Office, which writes policy forms for many, many other kinds of policies, gets them approved around the country by insurance regulators. They're the ones that create the general liability policy, get it approved, et cetera. But there's not much in the way of that in the cyber insurance market. So something else to focus in on here, which is preferred law firm and vendors, which is probably near and dear to the heart of many of the people that are listening right now. What I mean by that is cyber insurance policies pretty frequently require a policyholder who makes a claim or says, hey, I'm giving you notice because I need coverage here, to use a pre-vetted, pre-listed, preferred list of law firms to do that work. And so if you are a law firm that is not on that list, or you're an organization that wants to use your preferred firm, what do? Well, then you're calling up and you're saying to the carrier, for those who are giving notice, hey, gosh, I really, really want to use Smith & Jones. They're my firm. I've known them forever. I use them for everything. They know my business inside and out. I don't want to use a new law firm that doesn't know anything about me. And the adjuster will say, hey, appreciate you calling us. If you look at page 73 of your policy, you'll see there are 5 law firms that are our preferred firms. And we will not cover Smith & Jones's fees. You have to use one of those firms. Now, if you are a policyholder that has no relationship with a law firm with the experience in this front, that can be great. And there are some really, really great firms that do this kind of work that get an insane amount of volume from the carriers because these claims are just never ending. They help out quite a bit, and they're really fantastic at what they do. If you are dealing with, or you are at a large organization and you have a particular firm that you think is fantastic, they've got great cybersecurity and privacy lawyers, and you want them, best practice, go to your carrier, through your broker at the time you're buying and saying, hey, look, I love insert name of law firm. I want that law firm to represent me in the context of one of these matters, and say, I want them listed in the policy as a preferred firm. Even better practice is to say, and this is the rate that I want you to pay. Don't expect to get full coverage for full rates, but this can be something that can be added right into the policy.
What is BYOD and work from home?
Yeah, that's another great one. That's bring your own device and work from home. I mean, obviously, I'm at home. Mike is probably working remotely, and many of us, if not all of us, are, at least some and parts of the week. There are questions in a policy about policies usually driven by computer network. And what does that mean? Does that mean the network at the office? Does that mean it can include the cloud? Does it not? Does that mean that if people are on their own computers at home working away, is that going to be covered? Is that going to be excluded? Is that going to be left open? And there are some carriers that are adding endorsements, making changes to policies that will recognize explicitly coverage for devices and for people's employees' own devices that are operated remotely. So, okay, let's go to our next slide here. This is actually a nice add-on. You can get discounted cybersecurity services and work with people that are experts at discounted rates, or even like a free hour of time added in if you want to take steps in advance of an event that can be offered through your cyber insurance. Okay, so now you might say, well, I don't fully understand all of the people who are the quote unquote the players. What do you mean by all these people? Because there's a lot of people you probably haven't talked to as you move forward. Well, I've listed them all out. This is our little playlist. We've got defense counsel, and that's the lawyer that comes in to help out when there's been an event, figure out what obligations you have in terms of privacy laws. Those can be and should be paid for by the carrier. Forensic firms, again, come in and tell you what happened, how did it happen, why did it happen. Those firms come in, should be paid for by the insurer. Your insurance broker, these are the folks that help you get the policies. In a perfect world, working with an insurance broker that understands cyber insurance is much more helpful at the time of purchase and at the time of claim than someone who doesn't know the first thing about it. This is complicated stuff. This is not placing workers' comp. This is not placing kind of more straightforward policies. You'll find out that larger brokers have claim advocates who are people that say will help press the insurance carrier to cover your claim when need be. There's a wide variety of experience with that. There are people who are former coverage lawyers that take on that role. And there are people that have no legal training whatsoever. And I will not comment further. One of the things to be mindful of as a best practice is when dealing with a claim, no one likes hiring lawyers because we're expensive and we have bad reputations, et cetera. People say, oh, my broker will help me handle this. It could be fine, but because I'm here to warn you about, the black swan situations, there are decisions saying that materials exchanged with the broker are not privileged, nor are they work product. There are some decisions that go the other way, but being mindful of that fact is pretty helpful. So if it's a situation where somebody says in writing to the broker or to the carrier and copies the broker, oh yeah, we had terrible cybersecurity. We fired our head of IT and we don't want to spend any more money on that because we had other things to pay for, or we were aware of this, and that goes to the broker. Well, there is a risk, depending upon the judge, depending upon the court, depending upon the day, that can be discovered by the other side. And it also can be discovered by your insurance carrier as they're evaluating coverage, figure out whether it should be denied or should be upheld. And last, nearest and dearest to the hearts of Mike and me, coverage counsel. That's right, the people that help you figure out what the heck does my insurance policy mean, and what is my insurance carrier saying, and how do I deal with these people? We, in our roles, we are not recommended by the insurer, nor do they pay for us, so there's that. But we come in and we help twist the arm of insurance carriers to get them to pay claims. We also work with policyholders as they're submitting claims so that policyholders will insert their foot into their mouths less frequently. So what are the trapdoors? What are things that really trip people up as they are dealing with these three kinds of claims and figuring out what do we do here? And we have about 9 minutes left, so I'm not going to again read them all to you. And a lot of things I designed these things so that A, we can get CLE credit by actually having some substantive things in here rather than just pictures that I can talk about. B, so that they're takeaways for you for after the fact. But business email compromise coverage issues, there are several of them. And perhaps the most challenging is these come about in the context of good business relationships. And so what I mean by that is buyers and sellers are not usually one-offs. This is not a situation where it's someone you'll never see again, so you don't really care how you treat them. I mean, not that you want to be callous, but you have these companies have ongoing relationships and oftentimes are doing work that's valued significantly more than the amount of business email compromise. So what do? And that means that there can be demand letters without actually litigation, and how does this work, and how is the carrier going to cover it, and how is it framed?
And there's an incentive on the insured to resolve the claim rapidly, while the carrier might want to take its time with investigations and forensics and that sort of thing.
That's exactly right. That's exactly right, Mike. And it leads to a situation where for this, and actually I'll jump ahead to ransomware. The third-party lawsuit. This is what happens in resolutions with third parties. So 2.b.Romanet 3. These things are related because business people and in-house counsel say all the time after one of these events, you know what? Let's leave the litigators out of this. We don't want to ruin our relationship. We don't want litigators coming in and make a lot of money and going to court. And that doesn't help anybody except for the litigators. So let's just figure out a way to resolve this out of court. Let's resolve this through credits or something else. And let's do it quickly. Let's do it cheaply. Let's just be done and move on. And all those people will say, and you know what? It's best for everybody. It's best for us because we protect our relationships and our business. It resolves it quickly. We're not paying legal fees. And the insurance carrier is going to think this is the greatest idea too, because it keeps their costs low. Please, please, please talk to coverage counsel before you do that. Here's why. Because the insurance carrier says, boy, yeah, I hear what you're saying. And I say no to that. The reason is the insurance carrier says that they have a clause that allows them, that requires you to tell them before you admit any liability, and that before you settle it, there's a consent to settle clause and a cooperation clause. And they'll say that those mean you cannot do that. And if you do that and you do it on a fee credit situation, they'll say, well, by the way, we don't cover fee credits. Look at this exclusion from damages. So while you want to move quickly, doing so without your carrier, while thinking, how could the carrier possibly object? Let me tell you the ways that they would object. And so knowing about that and thinking about insurance issues before super helpful. Last thing I'll touch upon, PCI issues. If you're dealing with credit cards, I sure hope you have cyber insurance coverage. Pay close attention as a best practice for what the coverage says for PCI related events.
So is that also true if you accept payments via credit card? So like a lot of the people on this call may be lawyers. Would you need coverage then under a cyber insurance policy for those kind of payments that might be fraudulent?
Best practice, the answer is yes. And again, I admit that's the easy answer for me. Yes, because like if I say, well, you don't need coverage for that, and then someone gets a claim, they're like, well, that guy got us. I don't remember that, but he said I don't need it, and I'm going to go sue him. No, but more seriously, the likelihood of getting hit with a demand as a result of relying upon a third-party processor doesn't strike me as super high. It also is not zero, because I've dealt with many, many situations in which people say, oh, I've offloaded this liability, or I will not be responsible for, or I never touched credit card information. And lo and behold, they do and they do. And so they have liability as a result. So that is the concern there. I mean, you could certainly pore over your third-party provider's contract and see what it says. And if it's a situation in which you are 1,000% certain you never get a credit card number, you never pass it through, you don't even have it for a second, it's 100% done by a third party, then that would give you a layer of protection. But again, I've heard so many times, we don't have any responsibility, we don't have any liability, we don't have any of that data, and it turns out you do and you do and you do. Here's a general coverage trapdoor, and I was working with Mike on this in terms of where we stand on notice. So one of the nicest benefits of a cyber insurance policy is one of the largest trapdoors for a cyber insurance policy. Cyber insurance, as I mentioned, can and should provide coverage for the cost of forensics, right? And figuring out things right away. To get that covered, you need to tell your insurance carrier. The claim adjuster will tell you. And if you don't tell the claim adjuster, they'll say, well, we're not going to pay for that. And not only that, but you run the chance of blowing the chance to actually access the coverage because your notice was late. And this is a policy that claims made, which means it's only in place for a year. You didn't make the claim during the year, so you're out of luck. And I put in a couple of cases talking about that. I've also put in one that has a footnote to that idea, but it's pretty nerdy and happy to address it after the fact, especially since we're kind of getting down to the wire here. Consent to settle. This slide I talked about, which is the idea that always talk with your carrier to protect yourself best. This does become complicated when carriers say, well, woe is us. You only came to us 30 days ago, or we just found out about this 5 days ago, whatever it is. So we can't give you a position. The secret language to use there is to say, okay, and understand that, will you agree to waive the cooperation and consent clauses if we resolve things with this third party? What that is designed to do, pardon me, and many carriers will say, okay, is to say to them, hey, listen, you're going to let us settle. You, insurance carrier, will argue later about whether it's reasonable or even covered, but you will not deny coverage on the basis that we didn't cooperate or you didn't give your consent to settle. Now, some other issues here.
The theory behind that is that the insured and the insurer have the same incentive to settle, obviously, as painlessly as possible. So the danger of a settlement without consent under those circumstances to the carrier is fairly small. Really, what they want to battle about is coverage itself. But as far as paying money or giving credits or doing whatever to resolve the claim, the insurer and the insured are basically wearing the same pair of shoes there.
Yep, that's exactly right. That's exactly right. So a lot of these things I've talked about earlier in the deck, and again in here so that you can have some takeaways. One of the things here I note, and you're spoiled by having a statute that deals with when you've got a conflict of interest between the insurance carrier and your defense counsel, getting to pick independent counsel. Something to think about and think about the privilege
Insurance
issues.
Code Section 2860, ladies and gentlemen.
You've got it. Formerly the Cumis case, which was put into statutory law a while back. Some final best practices. Well, with my last few seconds here, final best practices are really, if you can, or if your clients can, reviewing the policies before they get them and asking for the full policy, asking for the endorsements, and understanding that these are not all created equally. And when there's been an event, paying it, so not only giving notice under multiple policies, paying close attention to what the carrier says and seeing, are there hidden trapdoors and are there places where they're going to say, well, we're denying coverage, and being mindful of that, because these policies are complicated, the claims are new, and paying attention to will allow you as the buyer or the policyholder, or you as the outside counsel, to put your client in the best situation to get the most coverage, which is what they thought they bought in the first place. With that, I think that's our entire hour. I appreciate you all joining. Appreciate you all listening.
Thank you very much, Scott. That was fascinating and very educational. Ladies and gentlemen, I hope that you enjoyed the program. This is one of the benefits of membership of the Beverly Hills Bar Association. Members get this kind of education for free. If you are a member, you know what I'm talking about. And if you aren't, please consider joining the Beverly Hills Bar Association. And we look forward to seeing you at the next program. Until then, have a good weekend and be well. Thanks.
Thanks, everybody.